Hello, I'm Tanisha Elliott Evans, and I work for the United States Office of Personnel Management in the Court Order Benefits Department.
I'm Sharon Peterson Isaac. I'm a senior paralegal specialist with the Court Order Benefits branch.
And we're here just to give you a general overview of the court order benefits. And we're here to provide just the background information as well as any information that will help assist you with your employees when they're transitioning to retirement. So OPM published new regulations on court orders in 1992. And it's Title V Code of Federal Regulations, Part 838. So generally, that's where we come from when we're governing court orders, and that's where excuse me, that's where our guidance comes from when we're processing court orders. We also have something called the Handbook for Attorneys. This book is used to assist attorneys when prepping court orders. It also has helpful information on how to prepare a court order. It actually has model paragraphs in it as well. OPM's role is purely ministerial. It's really administrative. And the mediator really belongs to the state courts. So we're just here to administer the court order. We don't take sides. We're really here just to go by what the court order says under the federal regulations. A court order related to divorce or separation can divide the civil service retirement system, which is also called CSRS, or the federal employees retirement system, which is called the FERS annuity. It can divide a refund of CSRS or FERS employment retirement contributions. It also can provide a survivor annuity payable upon the death of an employee or retiree, and a basic death benefit only under FERS. It also can permit a former spouse to continue coverage under the Federal Employees Health Benefits Plan. It can require an employee to cover his or her children under the Federal Employees Health Benefit Plan, and it can require an employee or retiree to assign his federal employees group life insurance coverage to a former spouse or children. It also can require benefits to be garnished for alimony, child support, child abuse cases, and Chapter 13 bankruptcies. Garnishments, though, require income withholding orders. So if someone is trying to garnish wages, we must have a formal income withholding order in order to do that.
Okay. A court order can also make a former spouse of an employee or annuitant eligible for federal employees' dental and vision insurance. In other words, FEDVIP benefits. It can require an agency or retirement system to enroll.
It cannot require.
It cannot require, I'm sorry. It can require an agency or retirement system to enroll an employee or annuitant in a FEDVIP plan to cover his or her children. It can make make a former spouse a qualified relative eligible to enroll in the federal long-term insurance program.
So basically, we just talked about benefits that can be required in the court order for us to divide. However, there are certain benefits that, regardless of whether it's in the court order or not, we're not able to divide that per federal regulation, and that's the FEDVIP. That's also to allow FEDVIP plan to cover his or her children. We will not be able to enforce that. We also cannot make a former spouse qualify relative to eligible to enroll in the federal long-term care insurance program. So that's those type of benefits we're not able to enforce via court order. A court order acceptable for processing means a court order that meets the regulatory requirements to effect an employee's annuity, a refund of contributions, or awards a former spouse survivor annuity. Any three of those benefits. To effect an employee's annuity or a refund of retirement contributions, a court order must specify its CSRS or FERS, it's a CSRS or FERS benefit, and refer to Part 5C of the CFR, Title 5 CFR Part 838. And it must expressly state that the former spouse is entitled to a portion of the employee annuity or refund. And it must expressly direct OPM to pay the former spouse directly or be silent on the payer, which we will default to ensuring that OPM is directed to pay the former spouse. A co-op or court order acceptable for processing must also provide sufficient instructions and information to OPM on how to compute the amount awarded to the former spouse, amount of the employee's annuity. In the case of a portion of employee annuity apportionment, it must specify the type of annuity for application, a formula, percentage, or fraction. So it must be really clear on how we're supposed to divide that benefit. We can't speculate. The formula must be present, and the variables in the formula must be very clear to understand so we can properly process it. We don't want to imply anything. Also, it's important to include whether we're dividing the share of the net annuity, the gross annuity, or the self-only annuity. Or sometimes a court order can even state a set amount. If it's a set amount of $500, make that clear in the court order, and we can divide it that way as well. Any one of those methods will do for an apportionment. To award a former spouse survivor annuity, a court order must specify a serves a first benefit and refer to our regulations, Title 5 of the CFR, Part 838. And it must expressly state that the former spouse is awarded a former spouse survivor annuity or direct an employee or annuitant to elect to provide a former spouse survivor annuity. Court orders can give the former spouse the option to elect a survivor annuity. Now, this is very important. We cannot assume that just because the apportionment is awarded, there's a survivor benefit automatically awarded. These are two separate benefits. So if it's the intent of the parties to award a survivor benefit, it must be clear and must be specified in the court order as well. And any type of language such as stating that it's the survivor benefit or describing the survivor benefit will be able to award. Also, the court can give the former spouse the choice to elect the survivor benefit. Not all former spouses may want that, so it's important to distinguish whether the former spouse can say, yes, I want it, and no, I don't, and decline the benefit. If that's not distinguished in the court order, and the court order just awards the survivor benefit outright, then the former spouse do not have the option to say to decline the survivor benefit, and we must give it to her. A co-op must also provide sufficient instructions and information to OPM to compute the amount of the former spouse survivor annuity. Just like we said in the apportionment, we must have clear instructions. Survivor annuity is the same way. It needs to be clear and concise as to what is awarded. Also, the survivor benefit needs to be issued prior to the date of the retirement or the death of the employee, whichever is earlier, or be in the first order dividing marital property after retirement benefits have commenced. Survivor benefits must be in that original court order if retirement has commenced, because if it's not in that original court order that divides property, then we will not be able to go back and amend the court order to award that survivor benefit. So this is one of those things that are very important to know up front, so the former spouse and the retiree is getting it right the first time around.
Can I add? Sure. And we will not accept a modification after the death of a retiree trying to amend a previous court order to award the former spouse a survivor benefit. Okay.
Also, if it's not specified how much of a survivor benefit that's in the court order, we will automatically award the max survivor benefit. So it's very important to specify how much. We can award up to the max or as little as $1. Do the same rules apply to the private sector employee? Private sector employees apply to federal employees and retirees? No. The rules governing federal employees' retirement benefits are in Title V of the United States Code, Section 8467, and the Title V of the Code of Federal Regulations, Part 838. Court orders that affect the private sector pensions are governed by the Employee Retirement Income Securities Act, also known as ERISA. However, CSRS and FERS are governmental plans and are exempt from ERISA. So this is very important. A lot of people will try to submit qualified domestic relations orders, which are normally governed under ERISA. They try to submit it to OPM to divide a federal pension. While we can accept quadros, that the qualified domestic relations order still must reference our regulations, which is Title V, Part 838, in order for us to divide it. So that's very important. It's not the same as private sector pensions. Where do attorneys find the rules that apply to court orders affecting federal retirement benefits? Here is a list of the regulations that we use, that attorneys can use, that govern everything that we use to divide the benefits of federal employees and retirees. I don't have to repeat them, but this is a resource for you to use. Also, like I stated earlier, we also have a handbook for attorneys for court order retirement, health benefits, life insurance under the Civil Service Retirement System, Federal Employees Retirement System, the Federal Health Benefits Program, and the Federal Employees Group Life Insurance Program. This is called a handbook for attorneys, but it's very helpful for all customers. You can actually use the handbook. It's very user-friendly, and here's a link as well that is online where you can be linked straight to the handbook, and it gives very helpful information as to how to prepare a court order. It gives model paragraphs, but it's still important that the intent of the court order matches exactly what is in the court order. So you really want to make sure that the customer is sure as to what has been awarded. What can a court order require from the annuity? A court order can apportion or divide a CSRS or FERS benefit as a result of a divorce, legal separation, or annulment of marriage. The court order must expressly direct OPM to pay a portion of the monthly CSRS or FERS benefit, as we stated earlier. And just to let you know, court orders normally are as the result of a divorce or a separation. So we do divide benefits if it's a legal separation as well. Also, a court order can require from the annuity apportionment benefits, payments to a former spouse from a retiree's annuity during the retiree's lifetime. That's an apportionment benefit. And survivor benefits is payment to the former spouse that begin after the employee or the retiree has died. The court order must have provided for a survivor annuity. Another type of benefit is a refund of contributions. A court order may provide that all or part of a refund of employees' retirement contributions be paid to the former spouse. So these are the three main benefits that can be provided in the court order: an apportionment, survivor, and refund of contributions. Apportionment benefits, payments to a former spouse from a retiree's annuity during a lifetime. We already went over that. And the survivor. As well with contributions, a court order also may block payments of a refund, but only if the order directs OPM not to pay the refund, and the order also grants a survivor annuity or a portion of a retiree annuity to a legally separated or former spouse. So if an employee is requesting a refund of contributions and there is a divorce and he or she has had a divorce, we must see the court order first to determine whether they can be granted those contributions. Because if there is a share awarded to the former spouse, we must give the former spouse her share as well. But sometimes the court order can outright tell us not to divide the refund, and then that prohibits us from dividing the refund. So we really are directed by the court orders on that matter. The former spouse share must be stated as a fixed amount, a percentage or a fraction of the annuity. A formula whose value is readily apparent from the face of the court order and information in our files. The amount cannot exceed the amount payable to the retiree after deductions for taxes and insurance. So, the annuity cannot exceed the net annuity of the retiree. So, we can award the former spouse everything up to 100% of his or her net annuity. But it must be clear in the court order exactly how much we're to give the former spouse.
Okay. When can a court order terminate a benefit? Apportionment benefits. An amended court order terminating an apportionment benefit can be implemented anytime after the benefit to the former spouse begins. A court order is also required to terminate benefits to a former spouse that are payable to the former spouse estate, fiduciary of the court, or surviving children of the marriage.
So, with apportionment benefits can be changed or amended at any given time, whether the retiree is still, or the employee is still employed, or if the employee is retired. We can accept amended court orders for apportionment purposes only at any given time, or it can just be a order to terminate the apportionment altogether. We can accept those as well. Also, it's very important to distinguish whether the apportionment needs to be left to the estate of the former spouse. If that language is in the court order, then even after the former spouse is deceased, if the retiree is still living, then the apportionment will be left to the estate of the former spouse or the children, whichever is specified in that court order. If it's silent on that issue, then we will automatically give the apportionment, refund the apportionment back to the retiree, and if the former spouse is deceased. Survivor benefits. An amended court order prior to retirement or death can terminate the awarding of a survivor benefit. Amended court orders are not acceptable for terminating the survivor benefit after retirement. We stated this earlier. A survivor benefit cannot be amended after retirement. So that kind of just marks the deadline right there. So you want to make sure the employee or the retiree is sure about that survivor benefit, because of course we know survivor benefits cost is similar to insurance premium. So after retirement, it cannot be changed, and the amount cannot be changed as well. So you want to make sure that's locked in correctly. Very important. A monthly survivor annuity may be payable after the death of the employee or annuitant if provided by a court order. Survivor election. A retiring employee may voluntarily elect a fully or partially reduced annuity to provide a former spouse survivor annuity. However, if the employee has remarried, this election may be made only if the current spouse consents to it. So, survivor benefits can either be awarded in the court order, or the annuitant can elect on his retirement application to provide a survivor benefit to his former spouse. We see cases like this all the time where he chooses voluntarily to elect to have a former spouse survivor benefit. However, if he is currently married, the current spouse will have to consent to this in signed documentation.
And it has to be notarized as well.
Yes. A court-ordered survivor annuity is not available unless the marriage lasted at least 9 months. It's very important. So that benefit can only be awarded to couples who have been married at least 9 months or more. Entitlement to a former spouse survivor annuity ends if the former spouse remarried before the age of 55, unless the employee and the former spouse were married for 30 years or longer. So, as we stated, that an amended court order cannot terminate a survivor benefit. However, if that former spouse remarries prior to the age of 55 and that retiree were not married longer than 30 years, then that survivor benefit will automatically terminate.
And please keep in mind that we will need actual proof. We will need verification of that remarriage by your former spouse, because OPM doesn't have that records, or we don't have access to them. So when you do retire and you know your former spouse has remarried prior to age 55, please submit that documentation with your retirement application.
Thank you. Death of an employee. How can survivor benefits be provided for a former spouse? Death of an employee. If an employee dies, a court-ordered survivor benefit is payable to a former spouse if the employee completed at least 18 months of credible civilian service and dies while under CSRS or FERS coverage. Under CSRS, a survivor annuity is payable. Under FERS, a survivor annuity and the basic employee death benefit, which is a lump sum benefit, is payable if the employee has at least 10 years of credible service. So these conditions are really important to remember if the customer is trying to award a survivor benefit. If it's a separated former employee, under CSRS, no former spouse survivor annuity is payable unless the employee died after age 62 and after filing the application for retirement benefits. Under FERS, former spouse survivor annuity is payable if the annuitant has title to a deferred annuity. The basic employee death benefit is also payable if not expressly excluded in the court order. Under CSRS, the maximum possible combined total of all current and former spouse survivor annuities is 55% of the unreduced annuity. A court order awarding survivor annuity to a former spouse reduces the maximum that he can be paid to the spouse married to the annuitant at this time of death. So the max survivor benefit will be under CSRS will be equal to 55% of that self-only annuity. Under FERS, the max survivor benefit will be equal to only 50% of the unreduced annuity. A court order awarding a survivor annuity to a former spouse reduces the maximum that can be paid to the spouse married to the annuitant at the time of the death. Restrictions on modification of court-ordered survivor benefits after retirement. It is very important that provisions intended to award a survivor annuity both reflect the intent of the parties and conform to the laws and regulations. Court orders affecting survivor benefits can be modified prior to retirement. Can be modified prior to retirement or death. Court orders cannot be modified to affect survivor benefits after an employee retires or dies. The only thing that can be modified about a survivor benefit after retirement is who pays for that, who pays the cost of the survivor benefit. Normally, it's automatically reduced from the annuitant to pay for the cost. However, the former spouse can be responsible for the cost, or she can share a portion of that cost if she's receiving that apportionment, and will reduce her apportionment to cover the cost. So if there's anything that's going to be changed about a survivor benefit after retirement, the only thing will be is who's responsible for that cost.
And also, please keep in mind, if the employee retires and is married at the time of retirement and provides a benefit for both, court-ordered for the former spouse, and he leaves a percentage for the current spouse, the former spouse is only responsible for her portion of the cost and not the current spouse cost. The retiree has to bear that.
Exactly. Thank you. It is, sorry, let me go to the next slide. Garnishment of benefits. Garnishment is a legal process under state law for enforcing existing legal obligations. Benefits under CSRS and FERS can be garnished only for alimony, child support, in cases of child abuse, and Chapter 13 bankruptcy. These are the only times that the annuity can be garnished. The garnishment must conform to all state law requirements for garnishment actions involving private employers and is subject to the limitations in Title V CFR Section 581. Limits on amount if you're remarried. An individual who has remarried and who is supporting the current spouse, dependent child, or other than a child awarded child support may be garnished up to 50% of the disposable income, or 55% if the garnishment is for support payment at least 3 months in arrears. So that's important to know that we only can garnish, in most cases, you only can garnish up to 50% of a retiree's annuity, and 55% in cases if the garnishment is three months or behind in arrears. Where to file a garnishment order? You can file, here's a resource. You can file it here at the Office of Personnel Management. The address is P.O. Box 17, Washington, D.C. 20044. For employees, of course, they should be sent directly to an employee agency. We have no authority over that until the employee actually retires.
Federal Employees Health Benefits, FEHBP. A former spouse who is awarded a portion of a CSRS or FERS annuity or a survival annuity by a qualifying court order, even though the benefit is not yet payable, may be eligible to enroll for health benefits coverage under the Federal Employees Health Benefits. And this is in Chapter 5 of the CFR 890-80. The former spouse is not eligible to retain coverage under the employee's family enrollment. They must be removed from the family plan, which means when that divorce occurs, the former spouse has to be immediately removed from that coverage. TCC, a former spouse who does not qualify for the Federal Employees Health Benefits may apply for temporary continuation of coverage. Conversion, a former spouse who loses coverage may convert to a non-FEHB individual policy with their insurance carrier. If the former spouse is going to apply for TCC and the person is retired, then you will contact OPM to handle that matter for you. The handbook for attorneys, the former spouse or their attorney should review the information in the attorney's handbook described earlier and contact the employee's personnel office. Federal Employees Dental and Vision Insurance Program, FEDVIP. Non-eligibility. Former spouses of employees or annuitants are not eligible for FEDVIP, even if a court order gives them FEHB eligibility. A court order cannot require an agency or retirement system to enroll an employee or annuitant in FEDVIP plan to cover his or her children if he or she refuses to do so.
What is the role of the employee's agency? Okay, the employing agency is the proper source of employment and pay information about service with that agency if needed during divorce. OPM does not receive records until after an employee separates from employment. However, if the employee had a previous employment in a different federal agency, information about contributions to the retirement fund during earlier service is available from OPM. The employee agency handles health insurance enrollments for former spouses and receives premiums as well as assignments of life insurance an employee may make. Requested information. The agency can provide, in response to a subpoena signed by a judge or a release signed by the employee, includes a statement of retirement system coverage, the amount of money withheld by the agency to the employee's credit in the retirement fund, and an annuity estimate using service to date. Agencies can prepare estimates of benefits the employee has already earned. However, an employee agency cannot determine the proper division of benefits between spouses or the present value of employee annuity, which must be determined by a private actuary. This is very important to understand that agencies nor OPM, because we get the requests as well, we cannot provide estimates to the retiree or the employee about how much the former spouse will be entitled to. You want to steer away from doing this because you don't want to commit yourself to saying that it's in this range. However, once other data becomes available at retirement, you realize that it's definitely a different amount. So you want to direct them to the appropriate officials that can assist them with that, but no one at OPM will be able to assist them with that until after they actually retire, when we have the data available to give an accurate amount of what the former spouse will be receiving. Again, agencies do not provide estimates that involve speculation or attempt to advise an employee, spouse, or attorney about how to draft a court order. We at OPM, Court Order Benefits, we do not provide advice of how to draft a court order. That's why a lot of regulations and resources are out there to provide assistance to the customers and to the attorneys as to how to draft court orders. This is one of the things you want to steer away from as well, because you don't want to give the appearance of being biased from one side or the other. Also, you don't want to assist in drafting a court order, and it could be something completely different from what is intended by the parties, and they may hold you to that information that was given to you, that you gave out. So you want to make sure you do not provide information on how to draft a court order. But again, like we stated, we do have the handbook for attorneys that is very helpful in drafting court orders, and you always can direct them to that resource. How can agencies assist OPM? Employees should not complete the voluntary election section with the former spouse's information unless they truly intend to voluntarily elect the survivor benefit. So do not, just because a survivor benefit was awarded in the court order, he's not, the retiree, he or she, they're not obligated to still put it on their election form, voluntary election form, that they want to voluntarily elect a survivor benefit. We're going to read the court order anyway, and we're going to determine how much the former spouses do. So it's very important to understand that. Agencies also can advise employees to provide complete divorce documents at the time of retirement. Full divorce decrees, any property settlement agreements, marriage certificates, death certificates. We just want a complete package of what happened so we can examine all the documents. A lot of times, sometimes it may just be the divorce decree. However, if that divorce decree is referencing other court orders in there, we need to get those court orders as well. Also, it's very important to understand that even if nothing is awarded to that former spouse, it's important for us to receive a copy of the divorce decree or separation agreements so we can make that determination ourselves. So it's very important for the agencies to let the employees know that we need a complete documentation in order to move that application forward. Also, if the former spouse remarries and she's no longer entitled to a survivor benefit, as Ms. Peterson was saying earlier, it's important to include that marriage certificate. Or even if the former spouse is deceased, you want to make sure that the retiree includes the death certificate as well, because that will affect the former spouse's benefits. And it's the duty is on the retiree to get these documents. So it's important to find whatever resources he can to reach out to whatever state agencies to get that correct marriage certificate or death certificate. What is the role of OPM? OPM authorizes payments in accordance with clear, specific, and express provisions of court orders acceptable for processing under the applicable provisions of law and regulations. If the order is not acceptable, if the order is not acceptable, the parties must return to state court to seek any necessary modifications. So we upon receiving a court order, if it does not meet our regulation and we cannot approve it for benefits, we will send the court order back to the customer, and it will be up to the customer to get a corrected court order with the state so we can enforce it. What is the role of OPM? To claim court order benefits from OPM, the former spouse or legal representative is responsible for filing a certified copy of the court order and all other required supporting information to OPM, keeping OPM advised of current mailing addresses of both the former spouse who is claiming benefits and the federal employee retiree whose benefits are being affected. So it's the responsibility of the employee to ensure that we have it's the responsibility of the former spouse to ensure that we have all documentation. And we must receive a court-certified copy of any court orders that are submitted to us. So if we're trying to divide the benefit and award funds to the former spouse, we need that actual seal. We need an actual seal copy from the state or imprinted ink. It's all different variations of how a jurisdiction will certify court orders. Just make sure it's court certified, and it cannot be a photocopy of a certified copy. It has to be the actual original certified stamp. If it's not, then we will have to return it back to the customer, which will delay the processing as well.
Also, please make sure that the signatures are with the court orders, that the judge actually signed the court orders, or if it's electronically signed by the courts, make sure that's legible somewhere where we can actually see it.
Absolutely. Also, it's important for the customer, the former spouse, to keep us updated on their mailing address. So sometimes the mailing address changes throughout the year, so it's important for them to write into OPM to let us know, because once the employee retires, we will get in contact with the former spouse by mail. So, it's important for them to remember to keep us updated on whenever they move so they can get the correct correspondence. Also, we need the claim court order benefits from OPM. The former spouse or legal representative is responsible for notifying OPM of any changes in circumstances that could affect entitlement to benefits and submitting all disputes with the employee retiree to the appropriate state court for resolution. If there's any circumstance that would change, such as a remarriage or death, it's important to get that marriage certificate, and it's important for the former spouse to inform us that that they have remarried, because it may change their benefits. Also, submitting all disputes with the employee retiree to the appropriate state court for resolution. Now, a lot of times they may submit a court order. The employee and the former spouse may submit a court order, and it's not exactly what they intended. OPM, we cannot go by intent of the court order. So if it is a court order, or if both sides have a dispute with that court order, it's going to be their responsibility to go back to the state court to provide clear guidance as to what is supposed to be done and to resubmit that court order to us.
And if by chance both parties agree that they don't want to have that benefit paid out, they must get an order vacating the previous order that awarded the former spouse a benefit. Okay.
Exactly. Yes. Upon determining an order is acceptable, OPM will inform the former spouse, employee retiree, and/or attorney the court order is acceptable, the date on which the spousal benefits are to begin, and the monthly benefit and/or formula used to compute the benefit. Obviously, if the employee has not retired yet, we will just approve the court order, and we'll send out a correspondence to all parties involved with the exact formula used in the court order and how we are going to divide it based on that formula at retirement. We will not be able to use actual figures because we don't have that information available, but we can put the formula inside the letter to let them know what formula we'll be using, and we'll take that straight from the court order. Also, the date in which the spousal benefits are to begin will be in the correspondence as well. Normally, it's the date of retirement, and if the employee is retired already, it will be normally 2 months out from when we submitted, when they submitted the court order. Disputes. If either party disagrees with the determination or calculations, a clarified court order may be necessary to change the effect of the court order awarding the annuity. If an individual contests the validity or amount, he or she must submit a court order invalidating or amending the one submitted by the former spouse. So if there's a dispute, we need a clarifying court order, as simple as that. We cannot speculate and guess what the parties intended. If one party is questioning whether that court order is valid, it's very important for that party to go to the court to get a court order stating that the one that we have is invalid. Because as long as that court order, has a court certified seal on it and is signed by a judge, we will process it. So if he or she is attempted to invalidate that court order, it's important for them to get another court order to letting us know that.
Any amended court order that invalidates an order that OPM has already processed should be sent to OPM as soon as possible. The new order will be reviewed and the parties will be notified of any changes to the benefit. So again, if an amended order is received or order to vacate is received, we will process that order the first of the second month in which that order was received, if the person is retired. And again, a lot of times when we send out the approval letters to all parties involved, they realize at that point that there may have been an error. So we do accept amended court orders. Even after retirement, we accept amended court orders. The only thing we cannot amend is the actual survivor benefit awarded. Application for benefits. A former spouse must apply in writing to be eligible for a court-awarded portion of an employee's annuity. No special form is required. If the former spouse is incompetent, a representative may apply in his or her behalf. Unless a court order is already on file at OPM, the application letter must be accompanied by a court-certified court order.
So in order to apply, you really want to make sure the former spouse applies in writing. However, there's no special form. Long as the information necessary is in that court order or even on the cover letter, that'll be fine. Usually the information that we need is the name of the retiree, the name of the former spouse, their current addresses, and social security numbers. The attorney can apply for the former spouse can apply on their own behalf, or even the retiree can apply for the former spouse. So any representative can apply for the former spouse, but you just want to make sure all relevant information is there so we can process the benefit.
Okay. A former spouse must apply in writing to be eligible for a court-awarded portion of an employee's annuity, unless a court order is already on file at OPM. The application letter must be accompanied by a court-certified copy of the order. No special form is required. If the former spouse is incompetent, a representative may apply in his or her behalf. The letter must request payment from the employee or retiree's retirement benefit, along with any other documentations issued as part of the court action. Included with the request must be a certification from the former spouse or his or her representative that the order is currently in force and has not been amended, superseded, or set aside. Now, if the former spouse benefit is payable, and that's for retirees only, we will need that direct deposit information. It's very important for Court Order Benefits Branch to get that information out to all former spouses, that we will not pay by paper check, we only pay by direct deposit.
Absolutely.
Okay.
There must be sufficient information to identify the employee or retiree, including the full name, as I stated earlier, the retirement claim number, if known, which is also called the CSA number, date of birth, Social Security, and Social Security number. OPM also needs the applicant's current address and that of the employee if he or she has not retired or died. When a court order is subject to termination upon remarriage, no payment can be made without a further statement that remarriage has not occurred. application for benefits. The materials, if a customer or employee, retiree, or former spouse is trying to apply for benefits, court order benefits, please mail the materials to United States Office of Personnel Management, Retirement Services, P.O. Box 17, Washington, D.C. 20044. If you have any other information or any questions that you need to ask, you can call 888-767-6738. Also, if you want to contact OPM, you can contact the customer service representatives are available on all federal work days from 7:30 a.m. to 7:45 p.m. Eastern Standard Time. You may also leave a message, again, at 888-767-6738. By email, you can mail retire@opm.gov. Also on the internet, there's a lot of helpful information at www.opm.gov/retire. So we just want to kind of sum up and give you some quick helpful pointers when speaking to any one of your customers, employees, if they have any, if they want any information about how to navigate the retirement process when there's a court order involved. So we're just going to give you these quick pointers. OPM will not be able to give estimates of retirement benefits or apportionments. Cover that. We're not able to do that. OPM will not divide the retirement benefit to the former spouse unless we receive a certified copy of the court orders with the intent to apply on the former spouse's behalf. A court awarded survivor benefit will trump any survivor benefit election. So even on the application, if the retiree elects not to give the former spouse anything, of course we have to go by what's in the court order. Okay. Also, you could always voluntarily elect for that former spouse to receive a higher survivor benefit, but it can't be lower. And it can't be lower than what's in the court order. It is not necessary to voluntarily elect a survivor benefit for a former spouse if there is a survivor benefit awarded in the court order. Again, like we explained earlier, we're going to go by the court order. However, if you want to voluntarily elect, it's your intent, it's the retiree's intent to voluntarily elect the former spouse to receive a benefit, then they can do that as well. Just make sure it's indicated on the application.
OPM, I'm sorry.
No, go ahead.
OPM does not provide health benefits for former spouses if the retiree is still employed by the agency. In order for the former spouse to receive HB, she must receive an approval letter from OPM and then submit the letter to the employing agency. If the former spouse doesn't receive her application, her approval letter from OPM, just have the former spouse contact OPM just to verify that the address that we have on record is accurate. And then we will submit another form of approval letter to the former spouse. If the former spouse's survivor benefit terminates due to death or remarriage, it is the responsibility of the retiree to provide OPM with a copy of the death certificate or marriage certification. The former spouse must send a copy of the divorce decree and any other court orders to OPM prior to the employee's retirement. All court orders must be included with the retirement application, even if the former spouse is not awarded anything.
And that's critical to know because it helps the retirement process to move along a little bit quicker because we won't have to go out and request any documentation. But if the retiree employee was married at any given time, whether the former spouse is receiving any type of benefit, it's important to send that court order in with the application. Also, it's not if the employee or the retiree do not have to worry that by sending the court order that they're applying for the former spouse. If it's not their intent to apply for that former spouse, they could just send us a copy of the court order so we can just double check to make sure the former spouse is not awarded a survivor benefit, and they can let us know that they're not trying to apply for the former spouse. Ultimately, it is the responsibility of the former spouse to apply if he or she wants that benefit. Also, the former spouse will not be paid after the until after the retirement is finalized. So even though the retiree may be putting interim pay until the retirement is finalized, the former spouse will not be receiving a portion of that interim pay until the actual retiree is receiving a final payment. Once the retiree is receiving his final payment, then we'll make sure the former spouse is set up to receive her share. Also, one of the points I wanted to cover is that sometimes it may be necessary to leave the former spouse in a court order of just $1. In circumstances like this, you'll leave $1 if you want the former spouse to qualify for federal health benefits. Because the only way that a former spouse can qualify to continue receiving federal health benefits is if she or he is awarded a share of the apportionment or survivor benefit. So if the employee retiree wants the former spouse to continue to benefit for the health benefit, federal health benefits, then all they really have to do is just leave $1 in the court order, leave them $1, and they'll be eligible for the health benefits.
Okay. And one other thing I wanted to add, please keep in mind that we honor the court order that awards the former spouse a survivor benefit. So if the court orders awards a maximum, a partial, or pro rata share, which is a percentage of the survivor benefit, we provide the former spouse with her benefit first. If you remarry or if the employee remarries prior to retirement, they oftentimes will write in to leave their current spouse the maximum. And we cannot honor that because we have to honor the court order. So the former spouse gets first precedence for the survivor benefit.
It's like first in time, first in right.
Yeah.
So since the former spouse was married to the employee or the retiree first, they will get entitlement to that survivor benefit first. So sometimes employees or retirees are confused about that because they may be currently married and trying to leave their current spouse a survivor benefit. However, if that former spouse was awarded a max survivor benefit, there will be nothing left to award to the current spouse. So it's important to get that survivor benefit right because, again, like we stated, that cannot be changed after retirement or death. Again, this is our contact information. For more information, please visit us at www.opm.gov/retiree. Also, again, my name is Tanisha Elliott, and I'm the Court Order Benefits Manager. My information is tanisha.elliott@opm.gov. That's my email address. And please feel free to email me any questions that you may have. If the customer or employee or retiree is having a difficult time to getting through on our lines, because we do have busy lines sometimes, feel free to shoot me an email. My phone number is below as well, which is 202-606-0473. But usually it's better to reach me by email if you have any questions, and I'll be happy to help you.